I don't know if I'll have enough copies, but I wanted to make sure that it was get it.
We'll see if the others get if you don't have enough.
Thank you.
Thank you, sir.
I'm a resident of Washington County in the 142nd District. Representative Mac Jackson looks after us and appreciate him being here. I'm an environmentalist. I'm a conservationist. I try to be a good steward of the land that I'm blessed to live on. My wife and I, we have a farm. We raise some cattle, we raise trees, grow hay. We raise children and grandchildren on a farm that we bought back in 1976. And about 15 years later, a landfill was built about a half a mile away from us. In fact, it's the one that's right across the highway from Mr. Young. We're neighbors. And so I come to know about landfills out of a case of necessity when one all of a sudden is so close to you. So we've learned a lot about them over the last 20 years, and I really appreciate this committee taking the time to hear from us. I'm confident that SB 110, as I've seen it written, is a threat to the water and the health and the welfare of Georgia citizens for generations to come, and it's based on 3 facts. Number one, landfills will leak. It's just simply a matter of time, and even our EPA tells us that. It's in a Federal Register, and the pages are in the appendix where you can read it yourself. It just happens. They break down and they'll leak over time. So what we're really talking about here is liners are just simply delaying the leakage that would otherwise occur in an unlined landfill. It's just going to be sometime later. The second thing is that this leachate that comes out of municipal solid waste landfills can be just as toxic as hazardous waste landfills. And I reference a study by Brown and Donnelly of Texas A&M in 1991 who sampled quite a number of municipal solid waste landfills and hazardous waste landfills. And those results are also for your pleasure of reading later. But that's the second point. And then the third point is that you shouldn't put large leaking landfills over significant groundwater recharge areas, and that is specifically what SB 110 intends to strike with paragraph 8. A question was asked earlier, is there a limit? Yes, there is, and I'll explain that. I think before you propose any changes in this regulation, I think we need to look at when and why the codes were written in the very beginning, and you can see what it was intended to protect. You just can't look at paragraph 8 in isolation. You've got to look at the paragraph before, which is section 212-8-25.2. And of course what it says is that if you live in an area of significant groundwater recharge or within even 2 miles of it, you've got to have a liner and a leachate collection system in the landfill. And then the next paragraph that follows is 12-8-25.3A, which Senate bill proposes to strike. It says by implication it limits the size of such a landfill by saying that it can only be used for the county's trash. In fact, it specifically says you can't take out a county trash. I don't know if it could have been worded any more eloquently, but what it intended to do was limit the size of the landfill to that that would be generated within the county that is willing to take the responsibility and the risk of putting a landfill in and start with. But it says if you're in one of these areas, it shouldn't be a big landfill, it should be a landfill that was intended for your county. And then the third paragraph, or paragraph B that follows, it recognizes the case of a county that might be too small to have its own landfill, and it allowed what could be called a regional landfill by entering into a joint contract with an adjacent county, but it had to be contiguous. In other words, they were sharing the risk of having a landfill together in these contiguous areas within a groundwater recharge. I'm convinced that the original intent of this code was to ensure that large regional landfills, which would eventually leak, were not put in the wrong places. and specifically large landfills ought not be put in an area of significant groundwater recharge. That was a good rule then, and I think it's an even more important rule today, because water and the threat to good water in our state is greater today than it was back in 1990. It was worded very correctly when counties own their landfills. It's only an issue today because of the more recent privatization of some of those landfills. In my opinion, rules for private companies operating landfills ought to be just as stringent as those for counties, because in counties, the citizens have more oversight and input to what's going on. But striking paragraph A opens the door for private waste companies to buy these small county landfills located in these significant groundwater recharge areas and then turn them into huge mega landfills. I'll give you an example. Someone asked earlier, when has this been used to stop something, or when has this rule been put into place? It was put into effect in December of last year when we stopped the sale of our Washington County landfill because of paragraph 8. It allowed us to stop it. It was the buyer had intended to increase the vertical, in other words, the height permit, and to be able to bring in out of county and out of state waste. And that was part of their bid proposal. It was clear that they intended to do that. Paragraph A, which Senate Bill 110 would strike out, stopped that sale in December. This is what I call the unintended consequences of SB 110. SB 110 is argued to be able to remedy an issue with Interstate Commerce Clause, but this was never intended to prohibit commerce. It was meant to protect the water, the health and welfare of Georgia citizens. And I beg you to amend this bill to give us the protection it provided earlier, or either vote this simply no on SB 110. Thank you for your time.
Thank you, sir. Question.